For the longest time I've been in those courts, I have heard the court repeatedly say that court orders are to be obeyed by all and sundry.
There are children who live on the orders that are in those files. Because I think child maintenance is something that is really sensitive and should be treated very differently from other matters in court.
So my case is dated 2009. The main hearing went through in, must have been in 2015. About May there, 2015 to about June. And I waited for the judgment. It just didn't come. Even as I'm waiting for the judgment, it got to a point now even the defendant is not honoring the interim orders of the court.
About 6 years after that, he stopped sending the amount of school fees that was due. When the school fees amount went up, he continued to pay as per the fee structure. But he woke up one morning and he decided he's not paying anymore. And then he actually demanded for a refund of the extra amounts.
So we go in for the hearing. On a matter of technicality, that application is thrown out, that you already have an agreement. First, see if you can enforce that agreement. One instance, I was with the High Court bailiff trying to execute a warrant of arrest, and we appear at the defendant's residence. Now, that was about the 5th warrant of arrest. And he asks, and who are you? So the bailiff introduces himself that I'm so and so, I've come for this and this issue. And the father of my child says, can I have a look at it? So he takes the warrant of arrest, he goes back to his house, bangs the gate and says, I'm not going anywhere. You can call the police to arrest me.
When I had made that application for reinstating the file, I remember part of the issues that I brought forth was the fact that he had not sent related expenses. So the court told me that the English on that particular order, I am quoting, the English on that particular order does not allow me to compel the defendant to pay for related expenses. I was actually made to read out aloud that order, and I was asked to interpret what it means. And I said that that could be either way. But then, interestingly, this was the only court that was looking at the interpretation of that order differently since 2010.
He would vacate orders even when none of the parties, neither me nor the defendant and his counsel, have sought for the vacation of those orders. He would vacate them. Now, when you vacate orders that are supposed to be for the best interest of a child, you're basically telling the defendant, for no apparent reason, I am now giving you a free pass to stop paying school fees and stop paying maintenance until I decide otherwise.
We go to these courts because we are aggrieved. Fast track the whole system because the children are suffering. By that time that an application is had for 24 months, is had and resolved is like 24 months. Those are 2 years gone. the child has milestones, you have to be in tandem with their needs. The court kindly consider these sort of things.